Attorney General Rhea received his Bachelor of Arts from Indiana University, graduating summa cum laude with honors, majoring in history, and graduating in 1967. He received his Master's of Arts in History from Harvard University in 1968, and he received his Juris Doctorate from Stanford University Law School in 1974. From 1968 to 1970, he worked as a teacher and community developer in the Peace Corps in Ethiopia. In the mid-1970s, Attorney General Rhea served as special assistant to the chief counsel of the Senate Select Committee on Intelligence Activities. Then in the early 1980s, he moved to the Virgin Islands, where he served as the United States Attorney. He was in private practice until he was appointed the 20th Attorney General of the Virgin Islands in August of 2024. Attorney General Rhea, you're very welcome. We're glad to have you. You got to see the last few rounds of arguments and see really the impressive caliber of the students, and you've gotten to read the fact pattern. So we look forward to hearing what you have to say.
Well, I have a few things to say. First, can you hear me okay? Is the sound all right?
Yes, you're coming through just great.
Okay, very good. Well, first, I have to say I've watched the arguments for the last, about an hour. I'm very impressed. This is a sharp set of students. And actually, I have to say I'm a little bit embarrassed because some of them argue much better than lawyers do. So I hope we see them in the courtrooms in the years to come. It gives me some hope for the future. So thank you very much for encouraging all of this with your moot court program. I think it's really, really great. I don't want to bog us down in a lot of legal details. I know everybody's are pretty much burned out by this point. But what I would like to do is just talk for a couple of minutes a little bit about my journey in the law. And I'd like to do that because I suspect many of the students here are considering pursuing careers in the law. And as you know, it's a long path. You have to get out of high school. You've got to go to college for 4 years and get a degree. You've got to go to law school for 3 more years. Then you may have to work as a clerk or a judge or heaven knows what, and then push forward. And some of you may be wondering, is it worth it? Does it take any kind of special background or any ways to get a leg up? Obviously, doing what you're doing now is giving you a leg up and giving you a taste of it. But what is there out there? So every lawyer probably has a different story as to how they got to where they got and what they're doing. Lots of twists and turns, a lot of different obstacles. But I just wanted to speak for 2 or 3 minutes to you first, a little bit about my background and what got me into lawyering. And some of you may find some inspiration in it. And it may also give you a little bit more of an understanding, not only of some of the things that can happen, but some of the very good things that can happen, some of the opportunities it gives you. I grew up in Appalachia, East Tennessee, basically a poor part of the country. My father only had 1 year of college, and my mother didn't even get out of high school. So obviously, background of parents, et cetera, is not going to make a huge difference in whether you end up becoming a lawyer, because I ultimately did become a lawyer. But I never even thought about becoming a lawyer until I was in my mid-20s. And I followed a lot of other careers. First thing I wanted to do when I was in high school was to be a musician. I played with rock and roll bands and jazz bands. I was a drummer and did a very good job of it and actually got a music scholarship to Indiana University. That lasted my career in music, at least my professional career at Indiana University, lasted about 6 months when I realized there were a lot of musicians who were a lot better than I was. So I went into a different field. I went into history and loved history as well. Graduated there and went to graduate school at Harvard, again in history. Did well there. I got my master's degree, but decided, I don't think I want to do this. Academia is kind of boring. Also, the civil rights movement was hitting full steam then. I was involved in a lot of the big civil rights protests, and also the Vietnam War was at its height, and I was one of those people you read about who was an opponent of the Vietnam War and quite vocal about it. So what I decided to do was to see if I could find ways to do some more good in the world. And I joined the U.S. Peace Corps. The Peace Corps training that I went through was done on St. Croix. And so I was here in 1968 on St. Croix as a Peace Corps volunteer being trained. And then was sent to Ethiopia, and I spent 2 years in Ethiopia as a Peace Corps volunteer. It was a life-changing experience, totally life-changing to be working in such a very different culture and in an extremely poor culture. If you were 25 years old, you were an old man in Ethiopia of those days, just because of the poverty and the tough experiences. Came back to the States in 1970, settled in California. Again, the civil rights and anti-war movements at that point were going full steam. And I decided, the best way to express myself, to make a difference, is to become a lawyer. And so at the tender age of 26, I enrolled in law school there at Stanford University. The law school is a 3-year process, and it was a very full 3 years. I had to work for a living because I came from a family that didn't have any money, and I didn't have much. Peace Corps didn't pay me very much money. Um, so I worked with a law firm for about 20 hours a week while I was in law school. I managed to get through all of that, did a lot of environmental law. I helped write Stanford's environmental law handbook. Um, but then was faced with another set of decisions that many of you may face if you go into law, and that is, what kind of law should I go into? What expresses me? The big law firms would come to Stanford and try to recruit students. That just wasn't the world I wanted to be in. I didn't want to spend my time representing the corporations. I wanted to help people. And so I ended up joining a criminal defense firm in Los Angeles, worked there for a year or so, and then had a fantastic time. The person who changed me most, I think, in law school and who woke me up to the things that lawyers can do was my criminal law professor, Tony Amsterdam. Tony Amsterdam represented virtually everyone on death row, people who were awaiting execution. And his advice still rings in my ears. One day we had a talk, and he said, "Gordon, if you don't like the way prisons get run, don't stand on the outside and carp. Become a prison warden." I thought, okay. That's an interesting thought. I can use law to get inside of entities that I feel need some change and some help. Well, after law school and working for a year or so as a criminal lawyer in LA, I got an astounding opportunity, and that was to work with a Senate investigating committee, a committee in Washington, D.C. that was investigating the FBI's attempts to undermine the civil rights movement and the CIA's attempts to assassinate foreign leaders. And so I ended up in Washington. It was a intense job, but one where I felt I could really make a difference. We made reports. We got a committee set up that became the permanent intelligence committee of the U.S. Senate. It was basically an opportunity of a lifetime. I was involved in writing the reports, again, on the FBI attempts to undermine civil rights movement and discredit Martin Luther King, as well as the CIA attempts to assassinate foreign leaders. When that committee ended in 1976, I didn't know what I was going to do. The head of the committee offered me a job back with his big law firm in New York City, and I said, that's just not me. Turns out he also had gone to law school with the United States Attorney in Washington, Earl Silbert. And he said, "What if I give Earl a call and see if you could become a federal prosecutor?" I said, "Now that sounds interesting." That all worked out. I became a federal prosecutor in Washington, did that for about 5 to 6 years, ended up as the executive assistant U.S. attorney, which is sort of the second in command of that entire office of about 160 federal prosecutors and attorneys. But then there was an administration change. The new president appointed a new U.S. attorney, who then asked me, of course, to step down because that's the way it works. I did that, but U.S. Virgin Islands needed a assistant U.S. attorney, a special one down here. So I came down to the U.S. Virgin Islands and worked based mainly out of St. Croix as a federal prosecutor down here. In 1983, I joined up with a local attorney, Thomas Alcon, and we began doing injury cases. We represented injured people. The oil refinery was going full steam, got involved in environmental litigation, and of course also did criminal defense work. And that was an extraordinarily rewarding time. I've been in private practice from 1983 through now. or basically through last year, which is 2024. So that was some 41 years in private practice after all that government time. And most of that time I spent again doing environmental litigation, criminal defense, and that sort of thing. In April of this past year, the governor asked me if I would be interested in serving as Attorney General, heading up the Virgin Islands Department of Justice. And being a crazy man, I said, sure, that sounds interesting. I said yes. I started working in May of 2024 and was ultimately confirmed in October of 2024. And I intend to keep doing this work until the end of the governor's term, which will be in January of 2027. Why did I decide to become an attorney general? Well, I saw it as a real opportunity to make a difference, a chance to give back to the community, and also to do what I just like doing, which is doing positive things. So let me just take a second to tell you about the Justice Department, because some of you may be interested in that kind of a career. What does the Justice Department do? Well, it has multiple divisions, and each of the divisions has a set of lawyers and also support staff. There's a criminal division that prosecutes all the criminal cases in the Superior Court or local court of the Virgin Islands. There's a white-collar crime division, which at this point is small, but I'm trying to build up, which focuses on economic crimes. We have a civil division that represents the government both in its own lawsuits and in suits that have been brought against the government. We have a Solicitor General's division that handles all of the appeals for the government, as well as reviews all departments' contracts for legal sufficiency. Quite busy division. There's a special investigation division, which basically helps attorneys on their cases, helps with victims assistance, that sort of thing. There's a division that looks at parents and parental and child support. We have a medical examiners division. We have a Medicare fraud unit, a sexual offender registry division, the gaming and casino division. The list goes on. It's a multifaceted job, but it keeps you plugged into a lot of different fascinating areas. What I want to do with the Justice Department? Well, I saw it as a chance to try to bring the Virgin Islands Justice Department up to fully modern standards. I'd like to add more employees, and I've been bringing in some new employees, and I'm pushing very hard on that to bring it up to strength. I brought down trial trainers from the National Association of Attorney Generals that have been working with that worked for a week with our attorneys and our support staff to satisfy us all that they were up to national standards. We're working on putting in a new case management system that's going to interface not only with the police department, but with the courts and with the defense bar so that we can get discovery out quickly, move cases faster, and get better and fairer resolutions. I'm also interested in fairer resolutions because I'm not a prosecutor that thinks everybody ought to go to jail. There's a lot of people that shouldn't go to jail, but who do need help. And so I'm a big believer in diversion programs, programs where people are not put in jail, but rather have to complete anger management, drug treatment, or whatever. And if they do all of that, then the case is dismissed because I think a lot of people need help. And I think this is a justice department, and helping people is a big part of justice. I'm also trying to reach out more to the public, keep the public informed about what we're doing and what we're trying to do. And I'm also reaching out to the Virgin Islands Police Department, the U.S. Attorney's Office, public defenders, the courts, all of the different other elements that have to work in tandem in order for justice to get done. So I can say in conclusion of all of this that looking back on my life, I'm very satisfied that I chose lawyering as my profession. It's given me endless opportunities to do positive and very interesting things. Everything from bringing justice to marginalized people, to helping injured people, to helping clean up the environment, trying to incentivize manufacturers to produce safer products, and improving the operations of a critical governmental agency, the Department of Justice. So I urge all of you who feel inspired by what you've been doing with the Moot Court program and by what you read about the law in general to please stay with it. Sometimes you get stuff. Sometimes you get criticized and hollered at unfairly. That's part of the game. Sometimes you got to work day and night. That's part of the game. But I can promise you, having done this now, I've been a lawyer for a little over 50 years in total. Um, it was worth it. It was a very positive and solid way to spend a life. And I encourage all of you who have the energy to do it and have the desire to do it to please push ahead. I was asked also just to say a word or two about one of the legal issues that I know you all have been thinking hard about, and that is, what about proximate cause? Okay, I don't want to sound like a judge or a lawyer too much, but let me just say a little bit about causation in civil cases. I know that plays a lot in a lot of the arguments that you've been doing and looking at. Proximate cause is a major element of a civil liability case. For a person or an entity to be liable for damages incurred by another person or another entity, the actor has to in some way have caused the injury or the damages. If there's no causal link, there can be no liability. So let's say that you're crossing the street in a crosswalk and I'm driving my car and I'm going too fast and I hit you and break your arm. Obviously, there's a direct causal link. I did it. And that's essential. On the other hand, if I'm driving my car and somebody 2 miles away is crossing a crosswalk and a different car hits them, I'm not liable for that because there's no causal link. But the plot thickens in some jurisdictions, actually in most of them. For me to be held liable for injuring you, I have to have done it either intentionally or negligently. In other words, on purpose or carelessly. And if I didn't injure you on purpose or out of carelessness, then I'm generally not liable to you, even if I injured you. Again, that's the way it comes out in most jurisdictions. So, in effect, the law says in this instance that even though you were injured through no fault of your own, and the person who injured you can be identified, me, if that person didn't mean to injure you and wasn't careless or negligent, then you can't collect damages for your injury from me. Okay, that may sound unfair, but that's the way it appears to run in most jurisdictions. But the plot thickens even more because there's an additional element. That element is whether the actor, even if negligent, could have reasonably foreseen the injuries that his accident caused. And I know that's been a big part of the case that you've been looking at. What does that mean? Well, let's say I'm driving 60 miles an hour through a marked school zone and I hit a student crossing the road in a crosswalk. My action clearly causes injury. I was clearly negligent for driving too fast through a school zone. And hitting a student crossing the road was a reasonably foreseeable and predictable outcome of my negligent behavior. So even under this more stringent test, I'm liable. But what about more remote causal links? Let's say I'm driving way too fast through a marked school zone and a rooster dashes into the road. I'm going too fast to avoid the rooster and I hit it. It knocks the rooster into the air and the rooster hits a student who's standing beside the road in the head and it injures him. Was my hitting the rooster and knocking the bird into the student's head the cause of the student's injury? Yes, because but for my negligent driving, I could have missed the rooster and the student wouldn't have been injured. Was my driving too fast in the school zone negligent? Oh, yeah. But was it reasonably foreseeable that by driving too fast in the school zone, I might hit a rooster that would slam into the head of a student standing beside the road? That's a tougher one. While driving too fast in the school zone raises a foreseeable risk that a student might get injured, the precise route by which the student is injured by a hit rooster that slams into his head doesn't strike me as predictable or foreseeable. But since I am at fault, having hit a rooster because I was driving negligently, and because my actions in fact caused a student to be injured, isn't it more fair to hold me responsible for the injury than to exonerate me because the peculiar means of harm was not predictable and thereby require the innocent student to bear the cost of his or her injury? Well, that doesn't sound very fair either. How do courts resolve that? Well, let's take a look at this fact pattern briefly that you've been looking at. It involves a boat negligently tied up at a dock that floats free, and a seaplane's flying overhead, and the pilot's distracted and fails to see the unmoored boat in his landing path. And it turns out that a van driving along a road on a bluff ahead of the plane has lost its brakes, causing the van to go over the bluff and land on the ground along the bluff's front. And it just so happens that the seaplane's pilot, because he was distracted and failed to notice the boat in his path, had to pull up suddenly, crashes into the bluff, and debris from his crash strikes the driver of the van. So who's responsible to the injured driver of the van for this fiasco? Well, what's predictable? What's negligent? What's foreseeable? Several parties clearly caused the injury. The problem with the van's brakes was a cause. The failure to train the van driver about how to avoid brake problems was a cause. The distraction of the seaplane's pilot was clearly a cause, and so was the failure of the boat's crew to properly moor the boat, because that failure is what caused the pilot to pull up at the last minute. Moreover, each of these failures that I've just described amounts to negligence by the party involved. But which of those negligent parties could have reasonably foreseen that their negligence might result in harm to a van driver or to anybody? Clearly, whoever knew the brakes were defective and failed to either fix them or to alert the van driver about the problem or train the van driver, they were negligent. And because of that, the van went over the bluff. Apparently, nobody got hurt when that happened, but that put the van in the place where debris from the seaplane would hit it when the seaplane crashed. Well, that's definitely not something that's very foreseeable. That the driver might be injured while driving a van with faulty brakes was clearly and reasonably foreseeable, but it wasn't really foreseeable by my reckoning that the faulty brakes would put the driver at a spot where a negligently piloted seaplane might crash and shower the driver with debris. So I have a hard time putting together foreseeable liability there on that part. What about the seaplane pilot? Well, I think he was pretty clearly negligent because he didn't pay close attention while he was flying his plane. And it was that very negligence that caused his plane to crash and shower the van driver with debris. While it might not have been reasonably foreseeable that a van driver would be in that very location, it was reasonably foreseeable that someone might be there and that injuries might result. And so it seems to me that his responsibility is pretty clear-cut. So I would blame that seaplane pilot for a lot of this. What about the boat crew? Well, they were certainly negligent in failing to properly moor the boat, but it stretches credulity to conclude that they should reasonably have foreseen that their actions might cause the pilot of a seaplane to immediately pull up, causing him to crash and shower bystanders with debris. They could, however, have reasonably foreseen that their negligence might cause their boat to hit another boat or to otherwise cause damage or injury. Should that be sufficient to hold them responsible? Well, most juries, as I'm sure you all know by now, most jurisdictions seem to leave it to juries to determine whether the link between a party's negligent act and the harm that act caused amounts to proximate cause. In short, the issue is treated as a factual determination. The proximity and foreseeability of the injury is left to the attorneys to argue and the jury to decide. This appears to be the approach taken by courts in the Virgin Islands. However, in some instances, a court may determine that the evidence is so slight as to not reasonably warrant the inference of proximate cause. And in those instances, the court is not required to leave the matter to the speculation of the jury. So basically, how much sense does it make to say that something was foreseeable or not? That's what it all boils down to. I took a brief look, and then I will leave you at Virgin Islands cases. And just to read one or two quotes from them to you so you'll know how it stands here in the U.S. Virgin Islands. It's pretty much along the lines I read to you and just explained to you. One of our lead cases says, quote, proximate cause is established where the party who bears the burden shows that an original act is wrongful or negligent and in a natural and continuous sequence produces a result which would not have taken place without the act. In other words, but for the negligent act, this event never would have happened. So that's part of our standard. The Virgin Islands Supreme Court has, quote, recognized foreseeability as the touchstone of premises liability in the Virgin Islands because foreseeability permeates every element of a negligence claim. So that's that foreseeability element that I was just talking to you about. Although foreseeability is implicated, the court says, to some degree in every element of negligence, each element requires a distinct and separate analysis. So the jury has to take a close look at this foreseeability issue. Another of our a different court, but one that we often rely upon here, says, quote, under tort law, the test for proximate cause is often foreseeability. If the harm that occurred was a foreseeable consequence of the action, then that action is a proximate cause of the harm. So again, foreseeability plays a huge part. Finally, that same case goes on and says, quote, a proximate cause is an actual cause that is also legally sufficient to support liability. Although many actual causes can exist for an injury, the law does not attach liability to all actors responsible for those causes. The likelihood of calling something a proximate cause increases as the cause becomes more direct and more necessary for the injury to occur. So that's where the standard stands. And reasonable people can differ on any given fact pattern, just about, as to whether or not it's foreseeable or not, and exactly what is meant by that. So enjoy your life in law, and I wish you all the very, very best. And if anybody has any questions or thoughts, I'm ready to entertain them.
I certainly have a few follow-ups on that. First, I don't know that I've ever regretted not thinking of a fact pattern more than your chicken scenario. Oh, like I really wish that had come up to my mind in January of this year when I was doing this because
Use it next year. Do it
right?
next year.
I mean, I there are so many cases that I've read that is like the Virgin Islands version of that. It's just great. Um, I actually, as the Attorney General, I think it would be good to maybe pose a question more related to the second issue. Um, I don't know that I've presented a question before that is more might more visually be depicted better than the serpent eating its tail than that issue, because the questioning on both days kept running into the same answers that brought you back to the same questions, and it didn't seem like there was an easy stop for either side. Yeah, you could always come back with another question that circled back around into the questioning, and I think this issue presents some very you know uh, values that are not just legal values in our society, but really significant values. I use the concept of legislative notice, right? The law needs to be published in advance, and people need to know it and understand it in order to be, or at least have the opportunity to know it and understand it in order to be liable. There's a reason our Constitution prohibits ex post facto laws, both against the federal government, but the original text actually prohibits that against the states. There are very few prohibitions against the states in the federal constitutions. It's one of them. The United States Supreme Court in V.I v. City of Columbia, they extended the concept of ex post facto law to the judiciary. In that case, the state Supreme Court had reinterpreted the law to make the defendant liable, and the Supreme Court said, well, you can apply that going forward, but you can't apply that retroactively
Oops, you
when
frozen
this
on me there. There
interpretation
you
had
go.
been out there.
Okay.
So, yeah, this issue today, we're dealing with the question of, well, separation of powers is huge. We have three branches of government, and if a bill doesn't get signed by the executive, as one of our moot litigators from Charlotte Amalie High School said on Tuesday, it's just a bill sitting on Capitol Hill. And that is just the heart of our checks and balances and separation of powers. But then it presents this other issue of, well, the law is published that people would access, says what was wrong. And what do you do with that? And I don't think that our legislature's direction, we included, I think it's 1 VIC something. I don't know that clearly says it other, because it says, well, the code reviser can only change grammar through mistake. But then it says, but if the legislature doesn't react to an error in a certain amount of time, the error becomes law. Well, okay, does the substantive prohibition on cha mistakes changing the law still apply, or is that second portion to all mistakes, whether it's substantive or not? So, I don't. What are your thoughts on that issue and how that sort of fits into our civil structure and how we sort of view limits on government and society?
Well, first, to be honest with you, I haven't thought a lot about that issue.
Fair, fair.
And I haven't researched it or looked into it to any depth. I haven't run into it. Fortunately, all of the massive number of civil cases I handled, I don't think there was ever a disparity between what was in the printed version of the rules and what had actually been passed. Although I do know that our printed versions are falling pretty far behind, and that's been a serious problem in several of the matters that we've had. No, but I agree that's an interesting argument. I think that would be a good one to work with on your next set of moot courts as well. Let me leave it there.
Right, make them go through it again. I think they might revolt against me if I put that in front of them. So, for the students, you've had an amazingly varied career, not just in law, but through your life. And you went to law school later than a lot of people do. A lot of people,
Yeah.
power through and don't stop. What advice would you give the students right now who are maybe considering it, but what would you say for them to try and do in order to decide if it is a career that would work? There's so many different parts to a career. What would you recommend to take on and see?
Well, I mean, obviously they couldn't start to go to law school until they had done their undergraduate work, their 4 years of college. And I would suggest that during that time, they try to go to court a few times, see what's happening. Um, we always love to have interns, and I know a lot of attorney general's offices, law firms, et cetera, like to bring in interns for a summer. And that's a great way to get a feel to see if this is something you're interested in or not. Law, though, as you know, is so varied. It can be everything from working with a Senate committee to trying cases, to preparing contracts, to doing wills. I mean, it's endless, and it's the sort of thing that gets you into all of the stuff of life. And as you know, um, on the criminal side, for instance, I've worked both sides, so to speak. I've done a lot of criminal defense work for many, many years, handled a lot of huge criminal cases, and I've done a whole lot of prosecution, including prosecuting a lot of very big cases as well. And I think seeing both sides and working both sides makes you better, and also gives you just a broader sense of justice of the fact that everybody that commits a crime isn't necessarily a bad person. It can come from a lot of different places, or is not necessarily an uncurable person or an unchangeable person. Um, and I think that's a positive side of working both sides. And so I would suggest students who think they might be interested in the law to maybe try a summer internship or something like that with a law firm that does a variety of things, or with a government agency, Justice Department, or virtually any other that deals with legal issues.
Yes, I actually a student from last year. It David Bourne is an attorney. His nephew interned at the V.I. DOJ. He really the feedback I got, he thought it was a great experience.
Mhm.
And that was through the Department of Labor. I assume that program is still going. So the
It is,
students.
yes.
Yeah, so students, you can get your applications in. Actually, the application period is coming up, I believe. It's either started already or it starts in May. But you go to the Department of Labor, you put your internship application in, and you say where you want to work. If you want to work at the Virgin Islands Department of Justice, you say that, and you can even, there's no guarantee you're going to be placed there, but if you want to go to the civil division, you can note that you want the civil division. If you want to be in collective bargaining for that, you can note that. You can note the Attorney General did a great job of sort of telling you the moving parts of that. Also, the Virgin Islands Supreme Court, they take interns every summer, and that isn't, for those of you who maybe already know you don't want to be a lawyer but are maybe interested in government work. The procurement division takes on an intern up there. It's not just like you're interning in a judge's chambers or something like that. You're getting that exposure. Judge Henderson, does the district court take on any interns through the Department of Labor program or anything?
I do not believe we do that through the Department of Labor program. I know at some point we did do that because I used to do that when I was in high school. This is where I worked every summer in high school and through college. And so I do know that we have had it in the past. Since I've been here, we have not had any interns. But that's not something that I can't inquire about. That's for sure.
Awesome. Please let me either get back to me or otherwise, I guess I could direct them to contact the general inquiry number about potential internships or whatever, and someone will talk to someone who will get back to them.
Yeah.
So, um,
Now, and also just throw out that another good reason to get into law, and it's sort of what got me down that track, was that if you get involved in a cause or something that you're really interested in, and it turns out that law can play a very big part in how those things get done, be it civil rights. We could go down the whole list of things. Law can be in a critical vehicle or route for getting things done, for aiming toward things. I mean, that's what got me actually to decide I'm going to go to law school because it's obvious the things I cared about. You need lawyers out there doing them, seeing that they work, and that can be a real incentive. So I'd ask people just to your students there just to keep that in mind. They may end up with many other interests. They may get absorbed in certain areas that are not legal, but it may be that if they became a lawyer, they could advance that area even more.
very true. To the schools, are there any questions? You've got, first off, any attorney general of any jurisdiction is a wonderful chance to ask questions of, but an attorney general like Attorney General Rhea with his just long history of experience and diverse experience is also great. Do any of the schools, you can obviously, turn your camera on, unmute your microphone or whatever and ask it, or you can send it to me in the chat. Do you have any questions for him, even specifically about interning or anything like that, or more generally, or anything? Because we have a little bit of time yet. We're not. I'm still waiting. About half of the scores are finalized. I still have the other half of the scores to go. So we'll be sitting in silence if we don't have questions either way. So. Um,
But you could sing or do something.
Right. Well, I will take the opportunity to again, anyone in the on here, I'm going to put the art auction fundraiser in the group chat. Like I said, please take a look at it. And even if I understand if you have no desire to purchase anything, I just ask that you look at it and then try to share it with three people who you think would be interested. Hopefully they would buy, but just interested. They'd think a piece on there is remarkable. As I said before, there's really some great opportunities for someone who collects art. There's Sherry Erickson and Don Dulka. They're two very well-known artists who sell for quite expensive. There's a $3,000 piece by Erickson for $1,000 opening bid, and there's a $19,000 piece by Don Dulka that's available for $9,000. But then on the other end, we have those wonderful historic photos that are reproduced, and they're I think someone has bid on, or they've been, all four of them have been bid on, so I think they're at $20 now. But still, that's a pretty low bid to make. So. As I said, it takes we need to raise another $17,000 in order to get back to in-person rounds of the competition, and do all of that. And we have about a year to do that. So, I would, just encourage all of that. And with that, I while we're waiting for the final, since no comments have come in the chat, uh, I guess we can take a few minutes break here, unless you have anything else that you want to say that came to mind, Attorney General Roy.
Well, I can talk on forever, but I think I think I've said what I really wanted to say, and that is I want to really encourage this group of students to take a serious
Um,
look at a legal career. And I have to repeat again, I was impressed as I watched the different arguments being made with how well prepared they were, with their demeanor, with the way they dealt with you judges. It was impressive, and that gives me real hope for the future.
I agree. I mean, in practice, I have definitely had people who aren't as good as the students I've dealt with here. There is a question actually that just came in.
Uh-oh.
So attorneys, judges, they point out that currently they're talking about implementing a medical school at UVI. What are your views on possibly a Virgin Islands School of Law or UVI School of Law?
Well, if you're asking me, I don't see anything wrong with it. I think it could be great. It would give uh, people an opportunity to go to law school here, uh, because otherwise it could be an extraordinarily expensive operation to have to go. Right now, to become a lawyer, you have to leave your home. You have to leave the Virgin Islands. You have to live in the States. And what I've seen, and I've seen it happen over the years, I've been a member of the Virgin Islands Bar for 42, 43 years. What I've seen is that the number of local Virgin Islands lawyers has actually been sort of decreasing. And that's because, well, one, there's several different reasons, but one big reason is if you go up to the States, you go through law school, 3 years, there's law firms up there that offer you good jobs. You stay and you don't come back. And I see that happening with some frequency. So many of the lawyers now practicing in the Virgin Islands live full time in Florida or wherever, and are members of the bar and kind of bounce back and forth. But there's fewer and fewer native Virgin Islanders who are actually that I've seen that are actually going into the practice of law. And I think a law school could really help that because then you would have grown up here, you could do your college here, do law school here, you would be a critical part of the community, an integral part of the community, and hopefully you would stay.
I would agree with all of that. What about the potential, people from the States coming to a law school and experiencing life in the Virgin Islands while learning the law?
I think that would be fantastic too, and I think that could well happen. And I really think that experiencing different cultures is critical. Like I said, I grew up in Appalachia and in East Tennessee in the mountains, which is one culture, very distinct. I lived all around the country in New England and Midwest and California, but then I also lived in Ethiopia for 2 years, and I was totally immersed in Ethiopian culture. I spoke Amharic. I still know some Amharic. I haven't spoken it a lot recently, but I had to live in a culture that was completely different from any I experienced before. But after a while, you settle in, you learn it, and also for stateside people down in who move to the Virgin Islands, there's several different cultures here that they have to get exposed to and incorporated into. And I think it broadens you. I think it helps you. It opens your eyes more. It makes you more tolerant, and it shows you that there's a lot of different ways that things can be done, not just one.
Yeah, I agree. I think if there would be one real benefit, in addition to local, Virgin Islanders going to school and being lawyers here, and how that would probably increase that percentage. Um, I think that a law school in a territory would be have a huge impact, no matter how small the number of attendees from the states there. I think it would have a huge impact in the consciousness of the law and what it means for territories and territorial rights. We had Professor Adams from Stetson University. She just hosted a symposium in the last like 18 months where it addressed sort of territorial law and what law schools could do to teach more about what the law is applied to the territories, because territorial status often has a different the law is just different. The incorporation doctrine means that if a law isn't written specifically to apply to the U.S. Virgin Islands, Guam, if those aren't written in the law and it just says the United States or doesn't say anything, the law doesn't apply to us. I mean, Obamacare doesn't apply to the Virgin Islands. At first it was interpreted to apply, and then it was reinterpreted not to apply, and we stand with it not applying in the Virgin Islands.
I have to agree with you.
So.
Make the difference.
I think that's a great question, or even I guess suggestion. It might even be than a question. So we are still a little over halfway here. So I guess let's take a 10-minute break, and we will reconvene. And I'll announce the scores then.
Oh,
Okay,
excuse me,
thank
Attorney
you.
Thorpe.
Yes.
I had a question for Attorney General Gordon. Do you think
Sure.
that future lawyers should go to the Peace Corps?
Do I think that, I'm sorry, you just broke up a little bit. Do I think lawyers should go to the Peace Corps?
Do you think that future lawyers should
Uh,
consider going to the Peace Corps?
yes, I think everybody should consider going to the Peace Corps. I know the Peace Corps enrollment has dropped considerably, um, but I think it's an astounding chance not only to do good and help people, but it also is a good way to experience different culture, which broadens you and makes you a much more open-minded and tolerant person. So I'd say yes, absolutely.
I think that's a wonderful question, and as someone who I didn't do the Peace Corps, but I was a national student exchange student to UVI in undergrad. I spent a year there. Um, my time at UVI led directly to me applying to law school at Howard University School of Law and attending there. Just, as someone who grew up in a very tiny area in rural northern Wisconsin, I wanted to, at least within the context of the United States, get as diverse of an educational background as I could. And so after a year at UVI, Howard seemed like the best opportunity for that. And I do think that I am not just a better person, but a better lawyer for that diverse background. There you obviously it makes you more tolerant. There's we know these things through multiple years of multiple sociological studies and stuff like that. But it also, I think, makes you more of a critical thinker. You're because you've had to learn different cultures and different perspectives and take that in. You're better at taking a moment to take in the situation and think it through, rather than just reacting from a narrow viewpoint.
Right. Yeah, I mean, to me, one of the um, major things I got from working in the Peace Corps and being in a little mud hut in the village in Ethiopia for 2 years, as the only English speaker, so I didn't speak English. I was totally immersed in the culture. Everybody I knew, talked with, met, etc., was an Ethiopian. And I worked in the schools there, and I also worked on some of the community projects. But what I really saw was that all sorts of things I had always just taken for granted, there are completely different ways to do them and think about them. And if you were to, I spent time in some other cultures as well and have seen them with yet other ways to do and think about the things that all people think about and do. And I realized that there's just a massive range. And I guess it made me into a cultural relativist.
Yeah, you don't, it doesn't go away. You don't magically just go back to not having that experience or thinking it definitely, uh, I think I have to agree. It changes you. Is, sorry, Amalia Law was Ms. Jaboynes the one more question, or do you have another question after that? Oh, okay. It was her. Um, so, all right then. Let me look here. We still have about three more squads who have scores being entered. So, yeah, I think we will now. First off, just a massive thank you to Attorney General Wray, who came in and did a wonderful a talk on, being a lawyer. The concept of proximate cause, I think, is just remarkable. I think that you gave real life scenarios and walked through the fact pattern in a way that we haven't done thus far, and so it was a really good a way to think about it in that regard. I liked it.
Thank you. It's an honor for me to be here. I really appreciate the invitation, the opportunity to talk to new aspiring potential lawyers.
Yeah.